Good morning, Mr. President, Your Honors. Thank you for the privilege of making these amicus curiae submissions before you today. These submissions are made in my personal capacity and on behalf of the former UN Special Rapporteurs on torture and other cruel, inhumane, and degrading treatment or punishment, namely Professor Manfred Nowak at the University of Vienna and Juan Mendez at American University, Washington College of Law, who himself is a torture survivor and named prisoner of conscience by Amnesty International, as well as the former UN Special Rapporteur on the promotion of truth, justice, reparation, and guarantees of non-recurrence, Professor Pablo de Greiff at New York University School of Law. The former UN Special Rapporteurs deeply regret that prior commitments prevent them from appearing in person before you today. By way of overview, amici contend that pretrial Chamber 2 erred on the merits of its decision of 12 April 2019, when it failed to authorize the prosecutor's Article 15 request for an authorization of an investigation into the situation in Afghanistan. This is because its interpretation and application of law therein was inconsistent with internationally recognized standards of human rights law in violation of Article 21(3) of the Rome Statute. For the specific reasons that follow, amici urge this chamber to reverse, thereby authorizing an investigation without further delay. First, in the impugned decision, pretrial Chamber 2 was satisfied that there is a reasonable basis to believe that as of 1st May 2003, Afghan national security forces widely practiced torture in Afghan government detention facilities, and members of the U.S. Armed Forces and the CIA committed the war crimes of torture and cruel treatment, outrages upon personal dignity, and rape and other forms of sexual violence pursuant to a policy approved by U.S. authorities. The Chamber correctly found that these incidents fall within the subject matter jurisdiction of this court as a war crime, and amici contend that they may also qualify as crimes against humanity under Article 7 of the Rome Statute. In addition, the Chamber rightly found that these incidents are admissible because of, quote, the gravity per se of the crime of torture, and the circumstances that the conducts have allegedly been committed by public officials in their functions, unquote. Amici underscore the pretrial Chamber's statement that torture is, quote, radically banned by international law, unquote, and that no derogation is permitted, even in times of armed conflict or terrorist attacks. This absolute prohibition is necessary for protecting the inherent dignity and integrity of all human beings, victims as well as potential perpetrators. Afghanistan and the United States are bound to abide by this jus cogens prohibition under customary and treaty law, specifically the United Nations Convention Against Torture, the CAT, the International Covenant on Civil and Political Rights, the ICCPR, and Common Article 3 of the 1949 Geneva Conventions. As a jus cogens prohibition, no state may enter into agreements for contracting around it, given the fundamental values it upholds. Second, under Articles 5 through 8 of the CAT, all states have an obligation to criminalize, investigate, prosecute, and punish torture wherever it occurs under the principle of aut dedere, aut judicare. Similarly, under the Rome Statute, where torture amounts to a war crime or crime against humanity, it is the duty of every state to exercise criminal jurisdiction over those responsible for international crimes under this statute. There is no discretion to address the breach otherwise. Here, as found by the pretrial Chamber, not one state with criminal jurisdiction over the incidents alleged in the prosecutor's request since 2003 has been able to exercise it, and therefore the investigation is admissible under the complementarity principle. While it is true that this finding was made on the basis of information available at the time of the prosecutor's request in 2017, the further information provided by the government of Afghanistan in these proceedings does not call the Chamber's conclusion into question. It still remains, as noted by the Chamber, that no national investigations have been initiated with respect to the prosecutor's request because, I emphasize, the request pertains to those who appear most responsible for alleged crimes. The same is true for the United States, and as noted by the pretrial chamber, both countries have focused thus far on cases limited to direct perpetrators or their immediate superiors. That said, amici recall under the jurisprudence of this court that admissibility is an ambulatory process. Amici welcome both Afghanistan and the United States or any other state informing the prosecutor as soon as possible of any progress made by national authorities, initiating an investigation against those most responsible for torture in Afghanistan, given that the prosecutor will have to continue revisiting the issue. Because no such information has been made available at this stage, however, this appeals chamber should not find that the pretrial chamber erred in the impugned decision with respect to its finding that an investigation by the prosecutor would be admissible under complementarity.
Excuse me, counsel.
Third,
I would like to ask you to slow down a little bit because of the
yes,
interpretation.
Thank you, Your Honor.
Thank you.
Third, failure by states to initiate a prompt criminal investigation, as is the case here, is itself a de facto denial of the rights to an effective remedy, reparations, and redress to victims of torture under the CAT and the ICCPR, as well as customary international law. Further, as stated by the UN High Commissioner for Human Rights and the Human Rights Council, it is a denial of the related rights to seek truth and accountability in the face of gross and systematic violations of human rights available to victims and society in the face of institutional policies enabling their occurrence. Criminal investigation is a necessary means to guarantee these rights and avoid recurrence of torture. As noted by the UN General Assembly, prompt initiation of a criminal investigation into allegations of torture, particularly where there is access by victims to the investigatory process, in and of itself provides an effective remedy, reparations, and redress. Failure by states to do so results in further injury to victims, eviscerates the prohibition against torture, and may itself constitute a violation of the prohibition, as has been found by the European Court of Human Rights and the Inter-American Court of Human Rights. Fourth, by extension, failure by the pretrial chamber to authorize investigation into this situation as the court of last resort because it found substantial reasons that it would not be in the interests of justice to do so, results in further injury to victims of torture. In this respect, regarding question CA of this chamber's decision on the conduct of proceedings, amici agree with the submissions made by the OPCV and LRV 1 and 2 that the pretrial chamber acted ultra vires in giving itself the power to look for such reasons under Article 53(1)(c) of the Rome Statute. Regarding question CB, amici contend that if this chamber nevertheless finds that the pretrial chamber may consider such reasons, then the chamber erred in its consideration of the factors at paras 91 through 95 of the impugned decision. For the reasons stated by the prosecution and LRV2, those factors were inappropriate because they impinge upon prosecutorial discretion and are in violation of the human right of non-discrimination codified under Article 21(3) of the Rome Statute. Amici add that the pretrial chamber erred in that section as well because it failed to properly weigh, quote, the gravity of the crime and the interests of victims, unquote, as required under Article 53(1)(c). Indeed, there is no reference at all to the per se gravity of torture therein. Further, the chamber's reference to the interests of victims at para 96 as a basis for its conclusion not to authorize an investigation is incorrect as a matter of law. This is because the Chamber omitted consideration of the rights of victims of torture to an effective remedy, reparations, and redress, as well as to seeking truth and accountability under international human rights law. Initiation of a criminal investigation into allegations of torture is an international legal obligation and, in and of itself, has reparative effect for victims. Blocking such investigation, on the other hand, purportedly on the basis of victims' own interests, has grave negative effect on torture victims, adding insult and further injury to that which they've already suffered. Consequently, the pretrial chamber effectively closed off the only available avenue for justice left to victims of incidents of torture in the prosecution's request. The chamber did so, even though, as it acknowledged, all jurisdictional and admissibility requirements under the statute are met. Declining to authorize an investigation because the relevant states refuse to cooperate is not in the interest of justice, but rather supports impunity. In fact, allowing states to get away with not investigating torture and other international crimes by those most responsible turns complementarity on its head. It is precisely for situations like this that the ICC exists. The impugned decision also dangerously signals that power is not bound by law. When it comes to torture, impunity simply cannot be tolerated, particularly with respect to the most powerful countries. The practice of such countries has ripple effects, leading to more torture and undermining of rule of law. As noted previously, when investigating alleged torture in Afghanistan, the prosecutor's strategy would be focused on those most responsible, those officials and policymakers with the power to effect widespread and systematic abuse. This is in line with the court's deterrence and prevention mandates, which are critical for the safety of the dedicated rank and file in militaries and intelligence agencies around the world. Where high-ranking superiors have complete disregard for international law's prohibition against torture and its underlying principle of reciprocity, they put their subordinates at great risk of torture upon capture. Finally, initiation of an investigation by the prosecutor here is substantially in the interests of justice for victims. In response to question C, this chamber should correct the pretrial chamber's error in limiting the scope of the investigation to incidents specifically mentioned in the prosecutor's request and authorized by the chamber, not only because of the reasons stated by the prosecutor and LRV2, but also because this would uphold victims' rights to an effective remedy, which requires a thorough investigatory process capable of leading to identification and punishment of those most responsible. Such investigation will, at last, take cognizance of the claims of numerous torture victims denied and silenced over 16 years. It will also be a critical step toward restoration of their dignity as rights holders. The victims well understand that there is no specific outcome guaranteed by an investigation by the prosecutor. Nevertheless, they overwhelmingly support one. What they are without question interested in and entitled to is a just process, one which states and this pretrial chamber have denied.
Professor Garry, you have 1 minute left.
Thank you. For the foregoing reasons, Amici respectfully request that the appeals chamber reverse the impugned decision and authorize the prosecutor's investigation into the situation in Afghanistan without delay. In so doing, to paraphrase the words of former U.S. Supreme Court Justice Robert Jackson as prosecutor before the Nuremberg Tribunal, the ICC will, by meeting violent acts of torture with an impartial, thorough, and just investigation into those most responsible for international crimes in Afghanistan, help prevent future such acts by cutting short a cycle of violence that was birthed following the tragic events of September 11th, 2001. As a citizen of the United States who cares deeply for its leadership role in upholding rule of international law, not undermining it, I implore the ICC to step in and fulfill its mandate where states have failed to address this vicious cycle. By doing so, the court will play an important role in moving all parties in the seemingly endless conflict in Afghanistan toward a future of healing, peace, and reconciliation. Thank you.